The law is simple. Threaten a witness, you face prison. Interfere with a federal proceeding, you face decades. Organize it from the top, you face life. That's not opinion. That's 18 U.S.C. Section 1512. And now, that law is sitting across from a president. A federal courtroom, late afternoon, controlled, procedural, predictable on the surface. But underneath it, something is breaking. Something that normally stays hidden behind legal language and formal process is suddenly exposed in real time. And you can feel it before you fully understand it because the tone shifts, the answers change, and the pressure stops being theoretical. This is not just another hearing about documents or timelines or political disputes dressed up as legal arguments. This is a moment where the system itself is being tested under stress, where the rules are no longer background assumptions but active weapons, and every word spoken carries consequences that cannot be undone once they are on the record. A witness takes the stand. The questioning begins like it always does, slow, methodical, building a timeline, payments, communications, who spoke to whom and when, prosecutors pressing forward, defense pushing back, everything structured, everything controlled, until the structure starts to crack under the weight of its own contradictions. Because what is being asked is not just what happened, but who ordered it, and that distinction is everything, because in federal law, the difference between participation and direction is the difference between exposure and collapse, between years and life, and everyone in that room understands it even if they don't say it out loud. And then it happens. Not gradually, not carefully. The witness breaks. No longer measured, no longer cautious, no longer filtered through legal strategy, just raw, uncontrolled, immediate. Trump ordered it. Those words land in the room without protection, without context, without spin, and for a moment everything stops, not because people don't understand what was said, but because they understand it too clearly, and there is no way to soften what it implies once it has been spoken under oath. And what follows matters just as much as what was said. The collapse is physical. The breakdown is visible. This is not performance, not rhetoric, not politics. This is pressure manifesting in real time. And in a courtroom, that kind of moment is never ignored, because it signals something deeper than testimony. It signals impact, fear, and the possibility that what is being described is not abstract but real enough to break someone in front of a judge. Judge Emmett Sullivan has seen decades of cases, routine and extraordinary, but even for someone at that level, this is not normal, and he responds the only way the system allows him to respond, by stopping everything, by resetting control, and then by doing something that changes the entire frame of what this hearing represents. He speaks, not through a written order, not through legal interpretation buried in documents, directly. And what he says is not ambiguous. Life without parole, not as speculation, not as commentary, as a legal consequence tied to the statute itself, tied to the evidence being discussed in that room, tied to the possibility that what was just alleged could meet the threshold of organized witness interference at the highest level, and in that moment, the courtroom stops being a stage for argument and becomes a place where reality catches up to power. And here's the part that doesn't get said out loud, but defines everything that follows. When a federal judge chooses to speak that directly, that clearly, that publicly, it means the system is no longer comfortable relying on assumptions. It means the guardrails that are supposed to operate quietly in the background are now being reinforced in front of everyone, because something about this case has crossed a line that can't be managed through normal procedure anymore. Because traditionally, judges don't do this. They don't step outside their rulings. They don't describe pressure. They don't warn in plain language. They let the process speak for itself, and the fact that this moment required something more than process tells you that process alone is no longer enough to contain what's happening. And that brings us to the second layer of this story, the one that runs parallel to the courtroom but shapes it just as much, because while testimony is unfolding inside, something else has been building outside for years, something that has turned judges from neutral arbiters into visible targets. Threats are not theoretical anymore. They are documented, they are increasing, they are escalating. Since 2020, attacks against federal judges have more than doubled, and since 2015, the number has more than tripled. And those are not just numbers, those are cases, families, homes, moments where the boundary between public office and private life collapses in ways that the system was never designed to absorb. A judge in New Jersey lost her son, shot by someone who came looking for her. A judge in Chicago lost family members to the same kind of targeted violence. That is the environment this courtroom exists in now. So when Judge Reggie Walton steps forward and speaks publicly about threats, about pressure, about what judges and their families are experiencing, that is not commentary, that is a signal, and it is coming from someone appointed by Republican presidents, which strips away the easy framing of partisanship and leaves only one conclusion. This is about the condition of the system itself. Now step back into the courtroom, because what was said there doesn't exist in isolation. The allegation, Trump ordered it, doesn't just raise a question of fact, it activates a legal framework, and that framework is built on intent, direction, and pattern, not just isolated actions, and that's where the pressure starts stacking. Because prosecutors are not looking at one statement. They are looking at sequences, communications, decisions about what gets revealed and what gets hidden. There are reports that materials were redacted, that certain documents were kept out of public view, and now the claim is that those same materials contain the evidence of direct instruction, which creates a contradiction that cannot hold forever, because either the redactions were routine or they were strategic, and those are not the same thing. And this is where the logic tightens. If someone denies involvement publicly but internal records suggest coordination, that gap becomes evidence. If testimony under oath conflicts with documents, that conflict becomes exposure. And if multiple individuals are now tied to the same sequence of events, one ordering, one executing, one concealing, then the case stops being about isolated behavior and starts looking like structure. That's what the statute is designed for. Not accidents, not misunderstandings, structure. And once you reach that threshold, the consequences are no longer negotiable. They are defined, written, codified, and waiting, not as theory, but as outcome. And that is exactly the moment this case is approaching. And this is where the story stops being legal and becomes human. Because while arguments are being made in that courtroom, while statutes are being cited and timelines reconstructed, the real consequences are not abstract. They are already playing out in the lives of people who never signed up to be part of this fight, people whose only role was to do their job inside a system that is now under pressure from the very forces it is supposed to regulate. Judges are not supposed to look over their shoulders when they go home. Their families are not supposed to be part of the risk calculation. Their children are not supposed to become collateral in a political ecosystem that rewards escalation over restraint. But that line has already been crossed. When a judge's son is killed by someone trying to reach her, when another judge's family is targeted in a separate attack, those are not isolated tragedies, those are warnings, and the system heard them, even if it didn't respond loudly at the time. And now those warnings are echoing inside every courtroom where cases like this are being heard. So when threats increase, when rhetoric escalates, when names and faces are repeated publicly in ways that turn legal actors into political targets, the impact doesn't stay online. It moves, it spreads, it manifests, and eventually it shows up in real places with real consequences, and the system has to decide whether it is going to treat that as background noise or as evidence of something deeper. And here's the contrast that matters. On one side, you have power, influence, the ability to shape narrative, to direct attention, to move millions of people with a single statement, to redefine what is acceptable simply by repeating it often enough. On the other side, you have individuals, judges, clerks, witnesses, people whose names are suddenly pulled into a spotlight they did not choose, people who are expected to remain impartial, professional, silent, even as the environment around them becomes more volatile with every passing day. That imbalance is not theoretical. It is structural. And when that structure is pushed far enough, something has to give. Either the rules bend to accommodate the pressure, or the system reasserts itself in ways that are visible, direct, and unavoidable. And what happened in that courtroom suggests that we are moving toward the second outcome. Because the warning, life without parole, is not just about one individual, it is about drawing a boundary. It is about re-establishing a line that has been blurred over time. It is about saying that there is still a point at which the system stops negotiating and starts enforcing. And yet, even with that warning on the record, even with the evidence stacking, even with the contradictions becoming harder to explain, there is one detail that reframes everything. Silence. Not strategic silence, not controlled messaging. Complete absence. Donald Trump, who has built his entire political identity on immediate response, on counterattack, on dominating the narrative before it can solidify, does nothing, no posts, no statements, no surrogates stepping in to redirect attention, just a gap where reaction should be, and that gap is not neutral. Because in a system where every word can be evidence, silence is not just absence, it is calculation, it is containment. It is the moment where legal reality overrides political instinct, and that shift tells you more about the seriousness of the situation than any public statement ever could. And that leads to the question that sits underneath all of this, the one that isn't being asked directly in the courtroom but is driving everything that happens inside it. What happens when power meets a limit it cannot bypass? Because that is the moment we are watching now, not a debate, not a narrative battle, but a collision between habit and boundary, between a lifetime of escaping consequences and a system that is finally signaling it may not bend any further. And when that collision happens, it does not look dramatic at first. It looks like hesitation, like silence, like something has paused that normally never stops. But underneath that pause, everything is accelerating. Lawyers are not thinking about messaging, they are thinking about exposure, about how every prior statement can be pulled back into the record, compared against testimony, measured against documents, and turned into a chain that either holds together or breaks under scrutiny. And when multiple people are now connected to that same chain, one testifying, one denying, one potentially contradicting, this stops being a single point of risk and becomes a network of vulnerability. Because this is how cases like this actually move forward. Not with one piece of evidence, not with one dramatic moment, but with accumulation, statement by statement, record by record, contradiction by contradiction, until the weight of it is no longer something you can spin or deflect or out-talk. And that is the stage this case is entering, where narrative stops mattering as much as consistency, and consistency is the one thing that cannot be manufactured after the fact. And while all of that is happening inside legal teams and court filings and sealed documents, outside that system, real people are still living with the consequences of how far this has already gone, judges still receiving threats, families still adjusting to risks that should not exist, a justice system that is now forced to operate in an environment where neutrality itself can become a trigger for backlash. That is the moral line in this story. On one side, the ability to push, to test, to challenge, to see how far the system can be stretched before it reacts. On the other side, the cost of that stretching measured not in headlines but in security details, in fear, in the normalization of behavior that used to be unthinkable and is now debated as if it were just another tactic. And when you look at it through that lens, this is no longer about one courtroom or one case or one political figure. It is about whether the rules that define the system are still rules, or whether they have become optional, dependent on who is being evaluated and how much pressure they can apply. Because the law at its core is not supposed to be conditional. It is supposed to apply consistently, predictably, regardless of position, regardless of influence, regardless of how uncomfortable the outcome might be for those at the top of the structure. And the moment that consistency breaks, the entire foundation begins to shift in ways that are difficult to reverse. So the question is no longer what was said in that courtroom. It is no longer whether a witness broke down or a judge issued a warning. The real question is what happens next. Does the system follow through on the boundaries it just reasserted, or does it step back into ambiguity the moment the pressure increases again? Because if the law only holds when it is easy to enforce, then it is not really law, it is preference, it is negotiation, it is something that can be adjusted depending on who is involved. And if that is true, then every future case inherits that instability. So here's the question that actually matters. If the law is clear, and the stakes are clear, and the warning has already been given, then what does it mean if nothing changes? If moments like this matter to you, if the integrity of the system matters to you, then don't just watch this play out, engage with it, leave your perspective in the comments, share this with someone who needs to see it, and subscribe, because this story doesn't end here.